Imagine you owe this staggering, completely life-altering debt.
Right.
But instead of making you pay it, the bank looks at you and says, well, just promise to be good for 5 years, and we'll pretend this never even happened.
This sounds possible, honestly.
It does, right. Now, imagine that debt isn't money. It's actually a 10-year prison sentence for taking a human life.
And that right there, that is the core conflict causing this massive uproar in a California coastal community right now. It's this situation where the really rigid rules of the law violently collide with the absolute power of a single person in a black robe.
Exactly. So welcome to the deep dive. Today we are unpacking the tragic case of Carly Howard, the mechanics of DUI laws, and how the justice system actually functions when it comes to judicial discretion.
That heavy one today.
It really is. So let's just get straight to the facts of May 1st, 2025. You have 29-year-old Katelyn Fultz crossing double yellow lines on Highway 154 in Santa Barbara.
Right. Highly dangerous stretch of road.
Yeah.
Very. And she crashes head-on into a car driven by 24-year-old Carly Grace Howard. Carly suffered catastrophic injuries, and she later died.
Yeah.
And when you pull the reports from that night, the statistics are just staggering. I mean, Fultz was driving with a revoked license.
Revoked. Not just expired, revoked.
Right. Her blood alcohol level was 0.167%, which is more than twice the legal limit. And she had cocaine in her system.
Which, for those who don't know, is this really dangerous compound that forms in your liver when you mix cocaine and alcohol?
Exactly. So because of all this, the district attorney recommended 10 years and 8 months in state prison. The Probation Department also wanted strict time. They recommended over 7 years.
Which sounds completely in line with the crime.
Right, but then a visiting judge sentenced Fultz to just 270 days in a local county jail.
Yeah, 270 days. And the reaction to that sentence, I mean, it was explosive. We're looking at official statements from the DA, public letters from the grieving family, and just pages and pages of community forums where citizens are demanding answers. Right. And as we've been looking through these case files, the deeper you look into the legal mechanics here, specifically how suspended sentences actually work, the more you realize that the justice system grants judges this ultimate power. They can just override strict legal guidelines, expert recommendations, and public outcry.
They absolutely can.
Yeah.
But to understand how a judge legally justifies, a few months in jail for a fatal crash, we first need to break down the sheer weight of the initial charges.
Okay, let's unpack this because the legal jargon can get really dense. Fultz entered an open plea of no contest to gross vehicular manslaughter while intoxicated.
Right.
Hold on, what do open plea and no contest actually mean mechanically?
Good question. So an open plea means the defense attorney and the prosecutor did not make a backroom deal.
Okay.
There was no agreed-upon sentence ahead of time. Fultz threw herself entirely at the mercy of the judge.
Got it. And no contest.
That means she accepted the criminal punishment without technically admitting civil liability for the crash. But by doing that, she left the final decision entirely in the hands of one person, Judge Brian Aronson.
Wow. And the crime she pleaded to, California Penal Code 191.5a, it's categorized incredibly strictly.
Oh, absolutely.
We reviewed these notes from the law offices of Benjamin Ockin. They focus on DUI defense, and they detail that vehicular manslaughter while intoxicated with gross negligence carries up to 10 years in state prison.
Yeah, and the phrase gross negligence is the linchpin there. Like, regular negligence might be taking your eyes off the road for a second to adjust the radio, right?
Sure.
But gross negligence is a conscious, reckless disregard for human life. The law specifically treats getting behind the wheel while highly intoxicated as this inherent deadly threat to public safety.
And the Santa Barbara County District Attorney, John T. Savernok, he focused heavily on those active choices. Following the sentencing, he issued this highly critical public statement where he laid out a timeline of her decision.
Right, he was very clear about it.
He said, Fultz chose to use cocaine, she chose to drink heavily, she chose to get behind the wheel, and she made all of those choices knowing she didn't even possess a valid driver's license.
Exactly. The DA used those facts to argue that a life was taken due to a chain of extreme, deliberate risks. So in his view, public safety and justice demanded a significant state prison sentence to match the severity of those choices.
Oh, okay, but I'm looking at the numbers here, and they just don't add up.
I know.
If the penal code outlines up to 10 years for gross negligence, and she had multiple intoxicating substances in her system, plus a revoked license,
Right.
how does the legal math reduce a decade in state prison to 270 days in a county jail? Like,
Yeah.
logistically, how does a judge bypass the DA and the probation office to do that?
So the mechanism the judge used is called a suspended sentence. Judge Aronson actually did hand down a 6-year state prison sentence.
Wait, he did?
He did, but then he suspended the execution of it. He also reduced a secondary DUI charge, which was for injuring Fultz's own passenger, down to a misdemeanor. So Fultz was ordered to serve 270 days in county jail and then complete 5 years of probation.
Okay, so going back to that debt analogy from earlier, if I owe a bank a fortune and they put the debt on pause, how does that work for a prison sentence? Does the state just, like, wipe the slate clean?
Not entirely. Under California's execution of sentence suspended, or ESS, the judge essentially presses pause on the prison time. Fultz serves her 270 days locally, and then she goes on to 5 years of probation.
Right.
If she follows every single rule for those 5 years, so completing community service, attending classes, never breaking the law, she avoids state prison completely.
And if she misses a payment on that debt, like say she skips a class or gets caught driving without a license again?
Then the judge can pull the pause button. At that point, the suspended sentence activates, and she's sent to state prison for the full 6-year term.
Oh, wow.
Yeah, the threat of that 6-year term hanging over her head is supposed to guarantee her good behavior.
But why does this mechanism even exist in the penal code? I mean, it feels like a massive loophole for violent crimes.
Well, historically, lawmakers designed suspended sentences to alleviate prison overcrowding, right? And to incentivize rehabilitation.
Okay.
The underlying philosophy is that some offenders can be reformed better in the community than in a prison cell.
But applying that logic, like prioritizing a hypothetical future rehabilitation over punishment for a past crime, that completely shatters when you introduce the actual victims into the courtroom.
Absolutely.
Using a suspended sentence for a low-level theft is one thing, but using it when a young woman lost her life due to extreme recklessness, that is what triggered the fury.
And that brings us to another major element of California law, which is Marsy's Law, also known formally as the California Victims' Bill of Rights.
Right.
This law fundamentally changed how victims participate in the criminal justice process. What's fascinating here is how it clashes with the judge's power.
Yeah, our sources list several constitutional rights guaranteed by Marsy's Law. Victims have the right to a speedy trial, the right to be treated with fairness, and crucially, the right to be heard at sentencing. And Carly Howard's family stood up in that courtroom. They delivered victim impact statements, telling the judge exactly how this crash destroyed their family, and they demanded a strict sentence.
But according to courtroom reports and statements from the family, Judge Aronson attempted to explain his lenient sentence by telling the grieving relatives it was, quote, what Carly would have wanted.
Man. You can see the immediate fallout from that comment in the public letter written by Carly's brother, Jacob Howard.
Yeah, that letter was intense.
His words just carry incredible pain. He called the judge's ruling cowardly and wicked.
Yeah.
He wrote directly to the judge stating, "You silenced Carly's cries for justice, cries that were delivered directly to you by her grieving family." He also accused the judge of being unimaginably pompous for claiming to speak for a deceased victim over the objections of her own blood relatives.
I mean, legal commentators in our notes flag that courtroom moment as highly unusual.
I can imagine.
But the interaction highlights the brutal reality of Marsy's Law when it meets judicial discretion. Marsy's Law guarantees victims a voice in the courtroom, right?
Yeah.
But it does not give them a veto over the outcome.
A voice, but not a veto.
Exactly. The judge has to let them speak, but legally, he doesn't have to listen to a word they say. The system is designed to separate personal vengeance from state punishment.
Wow.
So the law forces the judge to witness the family's pain, but the judge retains the ultimate authority to sentence the defendant however they see fit within the statutory limits.
Right. The desires of the victims, no matter how loudly they object, are just one factor.
Exactly. Just one factor among many.
So if you are listening to this, you might be wondering how the rest of the community reacted, because this did not just stay in the courtroom. Places like the Santa Barbara subreddit completely erupted.
Oh yeah, the community forums reveal a really deep distrust taking root. Users began actively accusing the local courts of operating a two-tiered justice system. You saw phrases like pretty privilege and white privilege being thrown around to explain the leniency.
And the anger really spiked when the community dug into Fultz's history. According to the forum discussions, this was the third time she had been caught driving without a license or in an unregistered vehicle.
third time.
Yeah. So people were looking at a repeat traffic offender who committed a fatal crime, and they started looking for hidden reasons behind the 270-day sentence.
Because when a sentence deviates this far from the DA's recommendation and the public's expectation, rumors just fill the vacuum.
Exactly. Multiple community members circulated claims that Fultz's brother is a local police officer.
Right.
Now, while our legal sources do not officially confirm that employment status, the belief that she had insider connections spread like wildfire. The community consensus was clear. If an average citizen without money or connections had crossed that double yellow line with cocaine and alcohol in their system, they would be sitting in state prison for a decade.
Right, and whether the rumors are true or not, the perception alone creates a crisis of legitimacy for the courts.
Yeah.
When the public believes the scales of justice are tipped by wealth, appearance, or connections, the moral authority of the legal system begins to crumble. I mean, some citizens even called for local businesses to ban Fultz and the judge.
Wow, so they were attempting to enforce social consequences because they felt the legal consequences failed so completely.
Exactly.
But wait, if the community, the district attorney, and the probation department all view her as a severe public threat, I just don't understand how the system legally justifies ignoring that threat at the end of the process. How does the system measure danger when someone is first arrested versus when they are sentenced?
If we connect this to the bigger picture, to see the contrast, we really need to examine the 2025 Santa Barbara felony bail schedule.
Okay.
This is basically the rule book that dictates what happens to a person the moment they are booked into jail, long before a trial or a sentencing hearing.
Right, and I'm looking at the schedule now. The very first page states that the primary consideration for releasing someone before their trial is the protection of the public, not rehabilitation. The goal at step 1 is keeping dangerous individuals off the streets.
Right, and the schedule also lists specific offenses that are strictly excluded from early pre-arraignment release.
Okay, like what?
Voluntary or involuntary vehicular manslaughter where negligence is a factor, excluded. DUI causing injury, excluded.
Wow.
The presumptive bail for gross vehicular manslaughter while intoxicated is set at $100,000.
And in Fultz's case, because of the severe enhancements involving the revoked license and the massive blood alcohol level, she was actually held on $250,000 bail.
Exactly.
So at the very beginning of the process, the system looks at the facts and slams the door. It says, you are far too dangerous to let out easily. We demand $250,000 as collateral just to trust you back in the community. The math is rigid.
It is. And the disparity between that $250,000 bail and the 270-day sentence illustrates a major paradox in our justice system. Lawmakers write incredibly strict rules for bail to protect the public immediately. They also write strict maximum sentences, like 10 years for gross vehicular manslaughter, to show how seriously the state takes the crime.
But then they build in a trap door.
Yes. They intentionally leave this massive window of absolute discretion for judges at the sentencing phase.
Right.
The philosophy is that justice requires a human element. Mandatory minimums and rigid formulas can't account for every nuance of a case, so the system relies on the wisdom of an individual judge to decide if a person is truly beyond rehabilitation.
But it creates severe whiplash for the public. I mean, the rules designed to protect families on the road are suddenly tossed out by the unpredictable human element of a single judge.
Yep.
The system allows that judge to prioritize mercy for the offender over the strict punishment demanded by the victims.
And because that judge's power is so absolute, the public is left feeling entirely helpless. The sentence is handed down, the gavel falls, and there's virtually no immediate recourse for the community to change it.
So what does this all mean? Let's pull all of these threads together.
Okay.
We started with the devastating, entirely preventable loss of Carly Howard. We examined the strict parameters of California Penal Code 191.5a, which demands severe consequences for gross vehicular manslaughter while intoxicated.
And we detail the mechanics of the suspended sentence, right? That controversial tool that puts a prison term on pause and relies on the threat of future punishment to enforce probation.
Right. We also looked at the agonizing reality of Marsy's Law. Victims are promised a voice in the courtroom, but when they face the absolute discretion of a judge, that voice can be ignored entirely.
Yeah.
The rigid protections meant to ensure public safety at the $250,000 bail stage simply vanish if a judge decides to lean toward extreme leniency at the sentencing stage.
The entire case serves as a stark reminder that laws are really just words on paper until a human being applies them.
Exactly. And that brings us to one final provocative thought for you to consider as we wrap up.
Let's hear it.
When a community feels a judge has failed them, the typical response is democracy. In California, local judges are usually elected by the community.
Right, which gives voters the ultimate power to hold the judicial branch accountable.
Exactly. If a judge makes decisions the public views as dangerous, the voters can remove them at the ballot box. But Judge Brian Aronson was not a sitting elected judge in Santa Barbara.
He wasn't.
No, he was a visiting retired judge.
Wow.
Yeah, the state brings in retired judges simply to help clear case backlogs. Because he's retired, he answers to no voters. His name will not appear on any local ballot.
So he's completely insulated.
Completely. He is legally shielded from the democratic consequences of the public's outrage over the sentence. He can hand down a ruling that shatters a community's faith in the courts and then simply return to his retirement. So as you think about the tragic loss of Carly Howard and the legal loopholes that turned a 10-year sentence into a 270-day jail term, ask yourself this. If the ultimate unchecked power in a courtroom is held by someone the community cannot even vote out, who is actually holding the scales of justice?